Welcome to the 266th session of Legal Empowerment Through Interaction lecture series. A wonderful topic indeed. Shared parenting, need for formulating practice guidelines. It may look good on paper, like shared parenting and things like that, but on the practical plane, end of the day, it's the child which matters. How far and to what extent and how we can. These are the issues that we might think of and deliberate today. And we got a wonderful panel in the sense like deliberations will be led by Justice Vijender Jain sir, who's a former Chief Justice of Punjab and Haryana High Court. And we have two experts in this field. One, of course, the master in the sense like say Anil Malhotra sir and Mrunalini Deshmukh ma'am. Both of them have been in this platform, and we have been indeed privileged by the exchange of ideas and thoughts that they were able to offer. And today we are privileged with the presence of Justice Ramakrishnan sir and all of you wonderful participants. And so without wasting any time, this being a thoroughly informal platform wherein what matters is only deliberations, discussions, and in-depth analysis of the topic alone, may I request Honorable Mr. Justice Vijender Jain sir to deliver or enter the introductory remarks. So over to you.
I'm really glad to be a part of your endeavor, which you have experimented during COVID. It is COVID actually has made in all spheres except the pharmaceutical companies and big persons who are connected with paramedical things and other things. Rest of them, they have said, all right, you sit down, use only video conferencing. So whether they are lawyers or judges, I'm sure inertia has set in. In this, your endeavor, Mr. Shyam, and when I saw Padman, so I thought that it has to do with your activity because you must be carrying always your laptop or something with you. So in these 2 years, having 263 or 266, if I'm correct, 266 webinar on various aspects of law is really remarkable. And when Mr. Anil Malhotra, he told me that this is how he has been interacting through these webinars, which has really become a source of data regarding legal issues involved in the life of people, consumer of justice, as well as people who are practicing law and who are administering justice. So he said, and I said, all right, I will join you for a few minutes. And you know what he told me? You have not to speak. You have to only chair. Because other my distinguished friends here who are the keynote speakers on this subject. It's a very interesting subject which you have chosen for your today's discussions and understanding. Because debate in this regard is going on for decades. I don't like to say many things because the people will like to hear from the experts. My experience as a lawyer, as 20 years as a judge, all kind of laws, though we talk about the welfare of child, but have we achieved that through either our legal bills, acts, and pronouncement by the court or not, that's a big question mark. Now, there are always two opinions of the why not we can't have joint custody for a child, because after all, there is, let us say, disharmony in the family. Marriage is disrupted for A reason or B reason. Apart from the person, spouse who are fighting each other, it is the child who is most affected in it. We talk about legal custody. We talk about not non-legal custody. But who is the sufferer? In certain cases, I have seen that a child who has been given a legal custody to the mother. Now, father has got visiting rights. Now, the visiting rights, they say on Saturday at 11:30, the father will come, take the child, till 6 o'clock, he has to return the child. Now, in law, it is a joint custody because the father has got the visiting right and the mother has got the legal right to look after the child. Now, but the child, for example, let us say he doesn't want to leave at 11:30. He wants to go, he's playing or not got up or have got some other place to go. Now, he has to be there at 11:30. This is what I am talking, some of the problems which is faced by a child. So if there is a law which can formulate and courts are capable of giving guidelines in terms of those, for the child welfare, what is paramount important, what is the need of it, we legislature, courts have to look towards it. I don't want to go into the enactments of the old colonial law of 1890 or the new act which has been formulated. I will leave it to the speakers to speak on those issues. But there has to be a harmonious relationship of law with the life of the child. How we can manage that? As the article written by Anil says that in UK, Australia, they have got a law to have that both parents have a joint custody of the child. But on the other hand, Japan and other countries, they are not having joint custody of the children. So this is the issue for which you have organized this seminar. I'm very happy to associate myself with it. Perhaps Shyam has not told you that I underwent a open heart surgery. So I told him that I will be limiting myself for some time to be here, and I would like to enjoy hearing the expert on this subject. With this, I inaugurate your webinar. Thank you very much.
Thank you. Thank you. Thank you. Thank you very much, sir. And the passion with which you are able to introduce the subject, and that will be taken upon by the experts today. The issue is regarding a child. It's not a chattel. So end of the day, when it comes to deciding, is it for the individual just to decide? Is it for the parties to decide? Is it for the legislature to decide how it has to be? Today, we'll hear it from the experts. And I'm grateful to you, sir, for having spent the time with us on this introductory remarks. And let us move on to Anil Malhotra, sir. Please, sir.
Thank you, Shyam. I'm very grateful and indebted to Honorable Justice Vijender Jain for coming out of his period of convalescence and being indisposed to inaugurate this very important occasion. I remember Honorable Chief Justice Jain, even while he was a judge, despite his preoccupation with judicial work, administrative work, he found time for social issues on weekends, and there was never an empty weekend on which he was not addressing the social issue. Thank you, sir.
No, you can also remind that when you organized that seminar,
Sir.
and you also wrote a book with
Sir.
regard to the plight of the NRI women.
Sir.
You sent me photograph today, and I remember that we had a very successful things, and we created a special court in Punjab after your seminar, because more than 25,000 women who are married to NRIs, they were abandoned.
Sir. So on this note, let me share with you, we have a common issue with Kerala. Abandoned NRI brides, or popularly known as holiday brides in Punjab. Now, at that point of time, the problem was a very big social issue. And I, as advisor of the NRI issues of the government of Punjab, had compiled a booklet, and we had organized with the help of the governor of Punjab and Honorable Chief Justice a seminar on. We had a full day interactive session in which we heard the various issues, and then Honorable Justice Jain was very, very passionate about resolving the matter. So he set up a special court, and fast track hearing of matters took place. And ultimately, Punjab is probably the only state to have a Punjab Compulsory Registration Marriages Act, by which this social issue was sought to be checked. So Honorable Justice Jain's endeavor goes back to my association with him in 2007, and the pictures of which I have shared with Mrunalini ma'am and Shyam also, that this was his impetus, this was his drive, this was his motivation on social issues, that he was alive, even though he was a judge, he would not hesitate to come on a social platform to help people ameliorate their grievances and provide solutions in the best possible way, maybe by structuring of courts, maybe by fast tracking of mechanisms or additional courts. And we also have now NRI courts whereby these issues are taken up in a fast track. Now coming on to the issue of children. United Nations Convention on the Rights of the Child was signed by India, and we amended the Juvenile Justice Act to carve out a definition of the best interest of the child. Now, if our children are our future, why are we not trying hard enough to build their future? It is easier to bring and repair strong children than to leave them in misery. Why can't we repair broken marriages? Children are the most important thing in your life. They can change you, they can make you, they can break you. Now, what is disturbing? What is discomforting? What is going wrong? In 2017, Justice Sikri and Vivek Singh and Romani Singh identified parental alienation syndrome as a serious psychological disorder which erupted when children were alienated and polarized on account of separation of persons. I have noted that there are 4 judgments in which this is the proof of the pudding has come in the way of the pronouncement. First is Jitinder Arora versus Sukriti Arora, 2017 Supreme Court 957. Now this is a case where 2 children were separated. The younger daughter was with the mother in England. The elder daughter was with the father in India. Once I was in London, the lady had met me and tried to sort out the medical issues of the child and what possibly could be done. But the litigation had gone on so long that when the matter was finally heard, the lady broke down in court because the elder daughter didn't want to see her anymore. And that was a sad story. The family split. Then came Prateek Gupta and Shilpa Gupta again in 2017, where again 2 children were separated. And the separation period, because of the litigation, led to such a gap that a long period of time had elapsed, and the child in India did not want to see the mother abroad and did not want to go over there. So then the matter was left to linger in the family court and maybe probably another miserable period of litigation. Now, then we saw Smriti Madan Kansagra's case. Now, this was a case between Perry Kansagra and Smriti Madan Kansagra, where after a 12-year litigation, the father was allowed to take the son back to India, back to Kenya, on the condition of a mirror order. 1 crore rupees was deposited in the Supreme Court registry. But when the time came for him to honor the mirror order, he refused to comply with the order, and the child refused to return the child to the mother in Delhi. She complained to the court. The court issued him notice. He did not even appear. The result was that the Supreme Court recalled its judgment. Now the man said, I have suffered so much, so now I am not going to honor this verdict. Again, a case of parental alienation. Then is the most significant case which has happened in the Supreme Court on 27th of January 2022. This is Gelna Khambata versus State of Maharashtra. A Bombay High Court judgment in a habeas corpus petition on behalf of the mother in the US wanted her 2 daughters back. I read the judgment which was provided by Mrunalini ma'am. It is a battle of litigation. It's a Parsi couple fighting over what law is applicable, whether Parsi law or English law, American law. How is the continuing litigation in both sides to go on? There are anti-injunction suits, there are divorce petitions, there are matrimonial settlement, and there is a brilliant amicable settlement attempt by Justice Rajiv Dar, Honorable Chief Justice of our High Court. Everything fails. So ultimately, the division bench of the Bombay High Court says there's nothing we can do. This habeas corpus will not succeed. The matter goes to Supreme Court. The petitioning mother, through her counsel, tries very hard to reconnect with her daughters. The first bench held by the Honorable Chief Justice makes an effort, gets the daughters online, and tries and talks to them. They are 15. There are one girl is 18 and one girl is 15. Now they have spent almost 3 years in India. They don't want to see their mother. So the petition is dismissed. Now, where are we heading? What is going on is the question which bothers me and which puts me into a dilemma about what is the law going to do about it. The other issue I see as a practitioner on the side is, our courts think of unilateral custody and choose mother or father as the custodian of the child and hand over the custody to that parent. The result is that when the time comes for the other parent to have his parenting time, I don't use the word visitation. I think visitation is to be used when you visit somebody in prison. When you want to meet your child, you are not doing a visitation. You are not doing a formal visit. You are doing parenting. So coming back to the topic, when you want to have your parenting time with the other parent refuses to honor the agreement. The child is not brought on video call. The child is not available for a visit. The child is not available to see the parent. So there is frustration. And in the pandemic times, redressal and approach to courts is becoming difficult. I did a matter which was widely reported in a habeas corpus decision, in a habeas corpus petition, where the mother had purportedly taken the children to England, but when the father visited the home in India, he found one of the children there. He moved in habeas corpus, custody was awarded, but then the Supreme Court stayed the order, so we are back to square one. So the effect is that there is something amiss in the whole scenario of this litigation, where we need a workup, where we need to do something. Now, Justice A.P. Shah did a brilliant job in report number 257 and then report number 263, where he gave us exhaustive amendment of the Guardian and Wards Act and the Hindu Minority and Guardianship Act to do away with the concept of singular custody, to introduce joint parenting, to introduce co-parenting, shared custody, and rights of parties and duties to children. But that, again, has never seen the light of the day. The Law Commission's reports is lying in the government archives gathering dust. Then came Justice Bindal Committee, of which I was also a part. We looked at the issue of interparental child removal. After a child was moved to England, I was an amicus for 12 long years. Nothing came out of it. So on a report submitted to the Law Commission, the committee was formed. We went into the issue, heard left behind parents, heard parents in custody of the children, gave a 2-volume report, recommended that the interparental child removal be defined, safeguards be set up, a mechanism be set up, and a bill was drafted and put in the 2-volume report. But again, we are where we were and nothing is happening. So now left with this scenario, left with this predicament, I have started to reading between the lines and trying to make the best of what we have today to see how the law can move forward. Now, it is in this context that my thinking out of the box has led me to this ideology, which I will put before you today and for the kind consideration of all people who are attending this webinar to see where is the path forward. A division bench of our High Court headed by Justice Ritu Bari has also asked the government to look into these issues and see if joint parenting is possible. But I think enactment of a law is very far away. Parliament will probably never have the time. Where the law makes money, like the Arbitration Act, it can be amended very fast. But when it relates to children and when it relates to marriages, I don't think anybody does anything. So it is in this context, let us go to the existing structure of the law and see what can we do with this law. So the first proposition is Section 3 of the Hindu, we all are Hindus, and most of us are governed by the Hindu Minority and Guardianship Act as our personal law. So Section 3 of the Hindu Minority and Guardianship Act, first of all, says that it is a supplementary law and it is supplemental and incidental to the Guardian and Wards Act and not overriding or in contradiction to. So therefore, the settlement is that the Guardian and Wards Act will be the overruling provision of law, and happily or unhappily, for wisdom best known to the Parliament, the Hindu Minority and Guardianship Act does not give you any route or statutory right to go to a court. So if you have to file a petition for guardianship or custody, you have to vest your right through the Guardian and Wards Act, read with the Hindu Minority and Guardianship Act. Now, Section 2B of the Hindu Minority and Guardianship Act talks of the definition of a guardian, and it includes a natural guardian. And Section 6 of the Hindu Minority and Guardianship Act, which is the most interesting provision and which on I think the whole fulcrum rests, is it defines who is a guardian. It defines what is the guardian's role. It says that the natural guardian of a child shall be the mother and father, they are both equal, provided that the custody of a child less than 5 years of age shall ordinarily be with the mother. Now, this gender mindset has got so entrenched in our system that the courts do not generally even look at the custody of a child shared or with the father if the child is less than 5 years of age. But there is a proviso now. Lahari Sakha Muri's decision 2019 7 SCC 311 says that the best interest of the child cannot remain the care and love of the primary caregiver, i.e. the mother. So the gender, the maternal preference has been in a way disapproved in Lahari Sakha Muri. Then we come to Vasudha Sethi, the latest decision in Criminal Appeal number 82 of 2022, decided on 12th of January 2022, where the Supreme Court says that the court can disturb the custody of the mother if it is not in the best interest of the child. And the welfare of the child gets preference over the rights of the parents. And wherever this happens, visitation rights will be given to the other parent for child welfare and not rights of parties. So where is this paradigm shift coming? This shift is coming in the Supreme Court's view in watering down and diluting the gender preference. I was an amicus in this case, which was decided by Honorable Justice Tyagi at the High Court. The High Court judgment has been upheld. Now, this is a clear indication that the Supreme Court has started saying that Section 6 does not give a parent any vested right of custody. So, what is it that takes the crunch? Section 8 SMGA, powers of a natural guardian. He can't be displaced. Section 13, welfare of the minor will be the paramount consideration. Now, let us come to the Guardian and Wards Act. Likewise, the Guardian and Wards Act in Section 4.2 defines the guardian. Then under Section 7 is the power of the court to make an order for guardianship. And Section 8 is the power of the person entitled to apply for the orders of guardianship. Now, the Guardian and Wards Act 1892, which is a colonial law, which was probably made by the British to suit their ends in resolving custody matters when we were colonized by them. But unhappily, we have carried on with this colonial law without even thinking that a child is not a piece of property which one parent can possess and keep like a table or a chair in his or her home. A child is also a person. Think of the child in a child-centric jurisprudence and decide his rights. What happens in any child custody case, be it habeas corpus or be it Guardian and Wards Act? It is more of a mudslinging fight between the houses. There is no talk of the child. So, what does the court do? Get caught in that trap, and it decides which parent has a superior right. As Justice Jain was putting it, the harmonious balance is lost. The court decides when the father or the mother will have visitation. But does anybody look at the child? When does the child want to be visited? This is an excellent example which Justice Jain gave. Nobody looks at the child. So, what is happening in our country? The litigation is more of a decision on the rights of parties, not on the rights of the child. So, therefore, let us look at the law as it is and let us try to see where the family courts can change. Now, if we read Section 12 of the Guardian and Wards Act, I'm going to read this to you because I have myself changed my way of looking at things after reading and rereading Section 12 of the Guardian and Wards Act. Now, Section 12 of the Guardian and Wards Act is power of the court to make interlocutory orders for protection of the child and protection of his personal property. So it says, the court may direct that the person, if any, having custody of the minor, shall produce him or cause him to be produced, and may make such order for temporary custody and protection of the person or property of the minor as it thinks proper. Now, I repeat the words order for temporary custody. Now, I have just read out to you that the father and mother are natural guardians. So the right of the natural guardian can't be done away with because that is a right which vests in you as a parent, as a natural parent of the child. So why can't we look at such order as a shared custody order or a joint parenting plan? Why does the court always think of singular custody when we look at the word order in temporary custody? So if the family court were to read in the words joint parenting, shared custody into such order for temporary custody, I think the problem can be looked into with an open mind and a child parenting and custody order may result. Now, Section 17 of the Guardian and Wards Act again talks of the welfare of the child in appointing a guardian and paramount consideration being the guardian. Section 26 of the Hindu Marriage Act also talks of orders for custody of the child. Now, who is to do this? Where is this to happen is the crunch. Now, if we look at the Family Courts Act, I think there is wholesome power in the Family Courts Act with the family court judges to do what I said. So shared parenting, joint custody can be read into Section 12 by what mechanism? By an inbuilt power conferred in the family courts under the Family Courts Act. How do I say so? First of all, Section 7 of the Family Courts Act gives the jurisdiction of the court. Now, Section 7, 1 explanation G says that the jurisdiction of the family court insofar guardianship, custody or access to minor. So where is the family court's jurisdiction? 1, guardianship, 2, custody, 3, access. So the family court has 3 missiles in its arsenal. 1, guardianship, 2, custody, 3, access. So this is the wholesome power of the family court. How is this power to be exercised? Section 9, duty of the family court to make a settlement. Now, when the family court has a statutory duty under Section 9 to make a settlement, I think the family court can easily twist the arms of the parties and say, bring a parenting plan, bring shared custody. Under Section 12, I am deciding interim custody first. By making an order, I am going to read the word joint custody and I'm going to read into the word parenting plan into Section 12 of the Guardian and Wards Act. I again reiterate Section 12 to say such order for temporary custody. Now, such order means joint or custody order, and temporary custody means shared by a parenting plan. Now, having said so, let us see the duty of the family court. In every suit, proceeding or endeavor made before the family court, the endeavor shall be to arrive at a settlement in respect of the subject matter. Then, if any suit or proceeding, it appears to the family court that there is a reasonable opportunity, family courts may adjourn the proceedings for such period as it thinks fit. Now, in Bombay, I've seen the matter it doesn't go to litigation straight, it goes to mediation first. Now, the next thing is the family court free of the shackles of the technicalities of law? Yes. Section 10 of the Family Courts Act says that the procedure of the family court shall be guided by the Civil Procedure Code. But then in the same breath, Section 10, subsection 3 says that nothing in this section shall prevent a family court from laying down its own procedure with a view to arrive at a settlement in respect of the subject matter or arriving at the truth alleged by one party or denied by the other. So the family court has a complete discretion to run down the procedure. And then in doing so, we have to read Section 13, right of legal representation. Now, Family Courts Act, like the labor courts under the Industrial Disputes Act, it is said that notwithstanding anything contained in this law, no party shall have a right of a family court to be represented by legal practitioners. Then, but what proviso? Provided that if the family court considers it necessary in the interest of justice, it may seek the assistance of a legal expert as amicus curiae. So this is something the court can use, pick up. Bombay has started appointing child independent lawyer. It's a very common feature to have this kind of a representation abroad, but this is something which can happen again. Now then, after the procedure being free from the shackles of the law of procedure, Section 14 frees it from law of evidence by saying a family court may receive any report, statement, documents, information or matter as it may deem fit to effectually deal with the dispute, whether the same would be otherwise relevant or admissible under the Aid and Evidence Act. So second thing, family court is free of the shackles of Evidence Act also. So under Section 14, any document can be taken as evidence minus the Indian Evidence Act. So I think the wholesome remedy is reading Section 12 to make such order for temporary custody and reading it with section 9, 10, 12 of the Family Courts Act to say that if we interpret the word to mean such order as a and temporary order, a joint parenting, shared parenting plan can come in. So till the Parliament amends the law, till there is a change in the statute, the words such order and temporary custody can be read down. Reading down is a provision which the Supreme Court says you must do to make the beneficial provisions of an act under interpretation. So I think this is the way I would look at it. And I think some innovation is required. But what do we need to do? I have been talking to family court judges. I think the family court judges, particularly in the northern jurisdiction, need a lot of inculcation. They need a lot of training under the judicial academies. They need new ideas. They need a discussion. They need a portal for coming together. The new lot is very bright, very promising, and has ideas, particularly the ones who have done a 5-year law course, or maybe the ones who are in their early 30s, have very good vision on these circumstances. Now, there is another issue which I must share with you. This concept of shared parenting, joint custody, is not free of any material. If we see the judgment of the Bombay High Court in Tushar Wale, 2016 Bombay 88, AIR 2016 Bombay 88, and Savita Sitaram, 2020 AIR Karnataka 372. There is ample material on how a parenting plan can be brought about. In JK versus NS 2019, SEC Online Delhi 9085, Delhi High Court has also laid it down. My advice as a practitioner, my suggestion as a practitioner is, it is the litigant, it is the lawyer who has to come up with a parenting plan and put it before the court. And I think he should insist before the court that in a section 12 application to decide interim custody, such order will mean a joint parenting plan, a joint custody order. It is a precedent which has to be settled. Family court will settle it, High Court will uphold it, Supreme Court will lay down the law. It will be better if it starts the reverse. Suppose Supreme Court was to do it, it would become a precedent in the shape of practice directions like Vishaka. It would become the law of the land under Article 141 of the Constitution. And it would be, and every due court would be duty bound to follow it. So whether it comes this way or whether it comes that way, I think this is the broad outline and the gist of how I look at it. But what is very disturbing is that starting from 1960, Gohar Begum, and going down to Yashita Sahu, Tejaswini Gaul, Lahari Sakhamuri, there is so much litigation, interparental, between continents when children are split across borders of various countries. It is equally bad when we are within the country. And I think the suffering is more when you are within the country. You live in a town 40, 50 kilometers away. You have a right, but you can't enforce it. There is no remedy available. You complain to the court. The court is not in a, your matter is not listed. You can't have a hearing. So these are practical issues. And I think the courts have to start looking at this issue in a very different way by maybe giving priority to cases on interim custody and settling them. So these are some of my thoughts. And I think Mrunalini ma'am may have a different experience of her side of the jurisdiction, and she may add her views. So and then we can put the floor open for questions. Thank you.
Thank you. Thank you, Anu sir. And in fact, it was an eye-opener for many of us in the sense like these are the issues with which child custody or something to do with somebody who cannot take decisions on their own is to be dealt with. Mrunalini ma'am, are you there?
Yes, of course. I mean, how can I
No. I'm sorry. I was just wondering. I was just wondering whether the issue should be left to the, with due respect to Jain sir as well, the decision-making process, even Ramakrishnan sir for that matter, to individual judges, or should there be a legislation in place? In the sense like, if something is structured, then you are bound by it. But end of the day, it's a child that's what matters. Ultimate.
First, I would like to hear Mr. Jain and, of course, this is Ramakrishnan, what he feels about it. But if you ask me, what should be the format in which the joint parenting and the joint guardianship should be there? I think number one, there needs to be an awakening in the judicial mind that such a concept exists. With utmost respect, I would like to say that today the judicial mind is still very, very fixated that custody is with a parent and visitation to the other. So in my understanding, I feel that unless there is that kind of, how do I say, a kind of a training given to the judicial mind to bring it, and that will bring about a lot of changes in the other cases. Mr. Jain, would you agree with me?
You have made a very, very good point, Mrunalini. I am of the opinion that judicial sensitivity is the hallmark of justice.
Ji.
Unfortunately, in our system of administration of justice, what we are lacking now is the sensitivity. You see that COVID, fine, but some of the courts are not functioning at all. Now, what is happening to the people of 86-year-old or like family dispute or custodial cases? Because very well, they said, nothing doing, we can't work, COVID is there. So it is how much a judge is sensitive. It depends on them. You make laws are there, and laws are interpreted. You, as a lawyer, you must have seen every day in court. You know that you go to a court, yeah, there are chances you may get a relief because just really try to understand things. There are some who say no, what is there? Why we should bother? The law says so. Supreme Court decide this, dismissed. The best thing for a judge is to dismiss. Citing Supreme Court, and the lawyer or the person concerned, the litigant says, I am not covered under this. They say, no, you are covered, dismissed. So if absolute discretion is given to a judge also, then it will depend which kind of a judge. And I am telling you with 53 years of experience in law, 24 years as a lawyer and 20 years as a judge. So it is also a luck. A lawyer knows it very well. If you go to this court, Baba, tera case to acha hai. Your case is very good. But you know, I don't know whether you get a relief or not. If you go to some other court, he said, no, he's a very good judge, you will get relief. So always, I feel it's a territory which we have to tread with great caution and difficulty. Absolute power to a judge. If judge is not sensitive, he will create havoc. This is my opinion. And I'm sorry, I will not be in a position to listen to you. I told Mr. Padman I'll be there for about an hour, half an hour rather I said, but it was captivating. Sometime else I will definitely join. I'm a little better.
Sure.
Thank you very much.
Thank you, sir.
Thank you very much, sir. I mean, you made a very pertinent point: subjective and objective justice.
Absolutely.
Ma'am, you can take on from there.
Thank you. So to all the participants here, a very warm good evening. After having sort of, listened with a lot of rapt in attention, Mr. Malhotra's exceedingly erudite, academically excellent, and of course, with all the practical case laws that he has given, I think he has made a very brilliant presentation and given us all an overall view of what this should be and how it should be tackled. After having said this, I mean, I'm really at a loss of words to express myself, but I shall try and make some feeble attempt to try and explain what my views on this are. I think I look at this subject with the same kind of sensitivity, with the same kind of passion and the same kind of zest, because Mr. Malhotra and me, we work a lot on cases which deal with the child custody issues, whether they're within the country or cross-border issues which are there. And I think both of us strongly feel that there is a very, very urgent need to bring about what is known as a shared parenting and what is known as joint legal custody, joint legal guardianship, and parenting time of as far as the children who are locked into the battle of these custody battles of the persons concerned. In fact, I would not be, I think it would not be inappropriate for me to say that history will always remind us that we have been unfair to the children who were locked in custody battles maybe a decade back or much more than that, and some of whom are suffering from the aftermath of a separation, or more so from a parental alienation. Now, what is parental alienation and what is shared custody and shared parenting? I think these are all interlinked. These are not individual concepts that we are talking about. And why do we need? So let's take a very simple example. That a child, if you ask any child, and this is my experience in that whom do you want to be with? He'll say, I want to be with both my parents. So there's very, very exceptional cases where they say that they want to be with A or they want to be with B. So which means inherently the child needs the care, custody, attention, etc. of both the parents. Now, if that is an inherent biological, psychological, emotional need of a child, then why is the law not making that as one of the preconditions in these custody battles? Why should it be that A parent should have the care and custody and B parent, as Mr. Malhotra rightly stated, comes as a Santa Claus or a Sunday daddy or a visiting person, comes, spends some time and goes away and says, okay, now the court say, okay, happy, you met your child, you spent 2 hours, you gave him gifts, you gave him an ice cream, now that's done. Now your role is over. Now please don't interfere in the mother's upbringing, which is there. I think this mindset has to change. And one of the reasons why this mindset needs to be changed is because, with utmost respect to the judiciary needs to take very strong steps to it. Today, in a way, if you see in all other matters, it is the judiciary which is really calling the shots. And in some sensitive cases, which may not be the family cases, which may be some other cases. So unless the judiciary takes cognizance of these facts and lays down what is known as a very ironclad legislation or a parenting plan, ironclad parenting plan to be able to be followed as a letter and spirit of law, these abusive behavior of custodial parents leading to a parental alienation will continue, and nothing on this earth will be able to stop that. Because today, the lower courts are just going, in this case, the Supreme Court has held this. In that case, the High Court has held it. The courts are supposed to decide on the facts and circumstances of the case and take these case laws as only a guiding principle. It cannot be applied verbatim in that sense of the word. Now, coming back to this, what I really feel is that how has the Indian law till now dealt with? Now, as we all know that the Guardians and Wards Act is a pre-independence, a colonial law, and Hindu Minority Guardianship Act, etc. has come post the codification of the Hindu law. And what are the provisions? I'm not going to get into those details. But this has been a situation when, if you see in sense of the statistics, there were less custody battles, there were less divorces, there were less separation. But today, what is the need? We really have to have a wake-up call. For the last 10, 15 years, at least me, and I'm sure there are some people who must be finding this even earlier than that, that our courts are flooded with custody battles. Our courts are flooded with these kind of visitation. Today, I don't know whether you are aware, a technical issue. Sometimes a client comes to me and says, my child is only a year old. She's with the mother. I don't want the custody. I want to have a visitation to her. I want to meet the child. I want to spend time with the child. I know my wife is nursing the child, so I don't want to take away the child, but spend time with the child. Do you know, as per the procedural law in the court, and Mr. Sasi Nair will second me on that, is I cannot make a simpliciter application to the court without any proceeding, only for the purposes of reaching the child. The courts tell me, make a custody petition. In that custody petition, make a application to be able to see the child. And see, I don't want the custody. Today, there is a difference between my wife and me. Post her delivery, she's not come back, but I want to see my child and she's not letting me do. What do I do? These are some of these small, I would not say a very major part of it, but these are the hindrances that we come across in having these kind of parenting. Secondly, and more importantly, as we have the judicial training which is given to the judges with regards to the way the family court matters have to be dealt with. And I think in Bombay, to speaking for myself, in Bombay, we have this at Uttan where they go and they do this. I think special classes and vocation training for the judges to deal with these issues are not only to be given by ex-judges, but have to be addressed by child counselors, have to be addressed by clinical psychologists, have to be addressed by children and parents, by lawyers who are dealing with exclusively custody matters, and also taking the help of the other paralegal forces which are around. Unless this is there and they train the judges to think in a particular manner, only then the judicial mind will start thinking on those lines. Today, it is very easy for a child. Yes, what is the age of the child? Or 4, custody to the mother. Father, you can see once a week, twice a week, whatever you want. And now you can have what is known as a virtual access. That's it. Enough. You've got enough. You wait, let the child grow up, he'll be there. No, the child needs the parent now. The child needs the parent when he's growing up. In fact, just before this thing, I had a virtual call with one of the clients, and I think it was a very interesting conversation that we had. His children are 5 and 4, 5 and 1. He says, I don't want to take away the kids from my wife. I want the children to be, because she's a good mother. She may be a bad wife, but she's a good mother. But I want to be equally responsible for being a part of their life, not only providing for them and not only meeting them occasionally. I should be able to take decisions for the child as to what things which are there. This is all what joint parenting is about. This is all what joint custody and shared custody is all about. That both the parties sit down together jointly, if possible. But if there is too much of a animosity between the parties, then take the help of a third person to be able to work out a plan which is in the best interest of the children. In all the judgments that the courts are giving, the courts say that we have decided this is the guiding principle for us is the best interest and welfare of the child. But these are very loosely used words, but they are not made applicable in the facts and circumstances of the case by providing a platform or by providing an infrastructure where this kind of shared parenting is there. They could also conduct studies to find out the effect of shared parenting on children and the effect of non-shared parenting on the children. I can tell you with a lot of conviction that obviously the children coming from a shared parenting background would be emotionally more stable, would be more blossoming into better human beings than children from a non-shared background. Now, these are the kind of things that are to be done for us to be able to bring about. Now, unless there is, and I would use a little stronger word, unless there is a revolutionary mind of the judiciary to deal with these problems, there cannot be by any of these sporadic judgments which have been laid down, sporadic judgment which has been laid down by the various courts, going to really become or change the face of the social structure which is there. The second thing that I want to talk about is that in most of the cases, the courts take that we will ascertain the wishes of the child and then decide. As Mr. Malhotra rightly said about the Delna Khambata matter, which was just concluded on 27th of this month, the issue before the court was that the courts were saying that the children are not willing to talk to their mother. That was the case there. Now the question is, should the children have a choice whether to talk to their father or not, or their mother? And why should they be given their choice, especially because when you're talking about children, they are minors. There are cases where mothers come to the court, and listen, please bear with me. I do a lot of cases for the mothers for their custody. And one of the things, if I can share my personal experience with all of you, is that I have lost quite a few cases when mothers came to me and saying that please ensure that the father does not get to see the face of the child, where I have returned the brief and I have told them, I'm so sorry, I'm not meant to be here, because then I would not be doing justice to the place where I'm sitting and to the matter that I'm doing. Where people can take a stand in a position, I'm not saying everybody is in that situation, but where people can take a stand and an awareness is brought about that it is in the best interest of your child. Forget whether the father gets it or not. It is in the best interest of your child. If you love your child, then you must ensure that the child spends time and quality interaction between the non-custodial parent and the child is always takes place. Thirdly, and more importantly, that I would like to sort of emphasize on this fact is, why does this happen? Why does a parent, suppose I'm the mother, I have the custody, why do I not want to share the custody or the parenting rights with my father? This arises out of a psychological issue. The mother, in most of the cases, this is my own observation over a period of time, that the mother who comes from a separation with her husband and comes with a child is emotionally, she has the baggage of insecurity that the marriage could not stay. I've lost my husband. Maybe his fault, maybe my fault, maybe our fault. Now I don't want to lose my child. Now this inherent insecurity that comes up in a lady's mind on the separation and these things further adds burden on the child's mind, further adds burden on the court's table to be able to decide this. The courts are not here to deal with these insecurities of a parent against the other parent. The courts, if they really have to follow the path of the best interest to a principle and the welfare which is there, will have to be, irrespective of the rights of the parties, what are the rights of the child. And that is why, as Mr. Malhotra said, that in some of the foreign courts, and we have also started this initiative by some of the Bar Council members, Mr. Shashi Nair will be able to help us better on that subject, and I would like him to talk about it, is of having an independent counsel for the child. So you have a lawyer for a father, you have a lawyer for a mother, but there is no lawyer for a child. Now the question that arises, what happens? Why should a child have a lawyer? The father's lawyer, the mother's lawyer will deal with it. So in the US courts, and I have personally dealt with those custody matters, so I can speak with a little bit of experience in that. There is a lawyer which is assigned to the child. The lawyer is to be paid by both the parties, the father and the mother. The lawyer has the advantage and the facility to use the child counselor, the child psychologist, the therapist, and do a home visit to the school and the home of the child concerned, and to be able to represent the child. Now, these kind of efforts, how many courts are taking? Today, your custody battle starts at a trial court. In how much time are they going to decide the visitation rights of a child? They'll say, oh, what's the age of the child? 4. No. As I said earlier, no. Only once, only twice you can see the child. Now, why can I see only once or twice? Why can I not see the child every single day for an hour if we are living at a distance of 10 or 15 minutes from each other? What is the logic behind it? No, you are interfering with the mother. How am I interfering with the mother? Am I interested in seeing the mother? No, I'm not. Ideally, I'm not, because we are separated. We have issues. But I need to be able to do that because I don't want to be a visiting thing. Secondly, the courts are very, sorry, this is not an attack on the courts. So please, friends, don't get me wrong. I'm not attacking the judiciary. I have all the judges over here. We have the greatest respect. We have the greatest reverence to them. And I'm sure they are doing a wonderful job. This is my plea and a cry as a lawyer who is representing both fathers and the mothers as to what the ground reality is, which sometimes the judiciary or the judges are not aware of, and it is not their fault. It is only because the way the system is, because there is hardly any interaction. A judge in a 10-minute interview with the child cannot decide, sir, who should the child be with, whether with the mother or with the father. This is not the way to go about it. There has to be a systematic study done. There has to be a pattern to be followed. There has to be use of professionals to be taken, to be arrived, because you are deciding the fate of a child. You are not deciding a right of a mother or a father. You are deciding the fate of a child. And hence there is a strong, greater responsibility than deciding a divorce or an alimony thing. I also see that when there are visitation orders, whether they are by consent or by the orders of the court, non-compliance of the order by a custodial parent, the courts are saying, why is it? Why have you not given? Come on, now start giving. That's the way they approach it. If the husband does not pay money for the wife, why are you not paying the money? I'm going to arrest you now. I'm going to ensure that you go behind bars. You have to pay right now. Otherwise, I'm going to attach. Are you come in a car? I'm going to attach the car. Now just see the tone of the judge in these two cases. If you are going to be aggressive, and you must be, because that is the role of the judiciary, to ensure that the maintenance, etc. orders which are granted by the courts are complied with, and that the as they call it, the judgment debtor does not run away, and he does it. Why cannot the same principle and the same passion be applied when there is a violation of a visitation and a joint parenting order? Why is it said, no, you'll sort it out, you'll talk to the counsel, you can do all these? Because that gives an impression to a lawyer or to a litigant who is there that the courts are okay if you don't give. They may just scream and shout and do something, but there's nothing which is going to happen. But if the husband does not pay the money, as has been mandated by the court, then obviously there are threats issued to him that I'm going to get you arrested, or I'm going to attach your vehicle or whatever other properties which are there. So to a large extent, I feel that it is a major, and I'm not absolving myself as an officer of the court, as a lawyer in doing this family matter. It is equally my responsibility as a lawyer, when a client comes to me, to be able to tell the client that no, you must give the child to the father, that is the husband, say 3 times a week or on a weekend which is there, unless you are able to tell me and prove it to me that he's a drunkard, he's a drug, he's an substance abuse, or he has got a severe mental or psychological illness, which is against the safety of the child. Yes, these are the exceptions which are there. Even the courts look at it. We don't want to jeopardize the child, whether it's physical safety, emotional safety, or mental safety. But we do understand that these things are a deterrent. But we also understand that just because somebody is fabricating, some things cannot be done. So the duty is cast upon me as a lawyer to ensure that the custodial parent who comes to me is responsible enough. I advise him or her, as the case may be, what is the position and what is in the best interest of the child. And secondly, it is also the judiciary which will have to take that little extra step to be able to arrive at these sort of, conclusions using all these situations which are there. Lastly, I would like to only add one more thing. That today, when we are talking about the child custody matters, and and we're talking about whether an independent lawyer should be given, whether there should be a shared parenting, the client's normal question is, ma'am, what is meant by joint legal custody? My wife is saying, no, she wants the sole custody, but I want to have a joint legal custody. What is the difference? So this kind of, how do I say, this kind of an orientation to the lawyers who are new lawyers coming into this field is required to be told what is the difference between a joint legal custody and what is the difference between a sole custody. What are the rights of the parents in a joint legal custody as compared to the sole custody? So today, if you see in US, now Mr. Malhotra has seen a lot of these cases where the parents take the children, run away from UK, run away from US, and they come down to India along with the children. Why? Because once a custody or a divorce matter is filed in the courts, the US courts in 9 out of 10 federal states, first they have joint legal custody, joint parenting. There is no concept of that I have the sole proprietorship of the child. Yes, they may then distinguish between what would be the primary residence of the children. Suppose the children are 2 and 3 and very young. Then the primary residence would be the mother. So all their things go on and so on and so forth. I'm dealing with a case, 2 top doctors of London who were caught in a custody battle. The letter goes, the letter from the solicitor goes that, we are filing for custody because that is the procedure solicitor files. The moment the wife, who is a doctor, comes to know that there is an intent of the husband to file for the custody of the child was, I think, 2 years or something. She comes to India along with the child, okay, abandons everything which is there, comes to the family court in Mumbai, gives a sob story and says that, listen, this is what it is. I've been in an oppressive marriage, etc. And now I've come here. Please protect me. Please protect me. Please grant me an injunction. Injunction saying that the child cannot be removed. Grant me guardianship, because if you don't give me the temporary guardianship, then no guardian, the court in UK will pass necessary orders and I may be compelled to hand over the child to mine. So the court say, oh, you've come under our umbrella and we'll surely protect you. Trust me, sir, the child, and I'm doing this case even now, the child, when was so-called parental abduction or whatever you may want to call it, I'm not here on the terminology. The child today was 2 years of age, was not given visitation to the father till the age of 6 or 7. 6 years the child has been in India. There are 3, 4 court orders of the UK court saying that she is the guardian, she's the ward of our court, and we are the guardian court and we have to do it. The mother has got a protection order from the Indian courts which are there. She did not allow the child to see the father, a very, very distinguished doctor. So it's not that he was an abuser or he was a very well-placed doctor. I'm talking about these healthy families. And today, after the courts have granted some virtual visitation because of, thanks to this COVID, today the child and the father are bonding like a house on fire. The child, the father, and I've been a witness to part of it, the father tells the girl, it's between 8:30 and 9:30 in the evening. The father tells the girl that, listen, baby, it's 9:30. I think you should go to bed. The time is also over. I'll talk to you. She says, no, daddy, please talk to me some more. Please tell me what happened in your hospital. Please tell me how is it snowing outside. So the child wants to engage in this. She wants to get into it. And today the father is saying, no, you must have a disciplined life. You have to go to bed at a particular time because you have to go to school. Have you not deprived the child for 7 years of this wonderful interaction that she would otherwise have had? Why? Because I don't want to say anything more. So these are the kind of changes that we need to bring about. And the biggest onslaught of this is the parental alienation that we will discuss at some other time and forum, how it is counterproductive for the well-being of the child. In my own cases, and I'm giving you only my cases so that I can talk with a little bit of conviction rather than what probably the case laws they have been laid down. And I can tell you in 2 of the cases where the custody battle started with, for 3 years, the child was with the mother. Thereafter, one day she went to the father and she refused to come back. She was repressed and repressed and repressed for 4 to 5 years, not allowing to see the father. The moment she went to the father's house and maybe she got a little accustomed and she saw that there's so much of joy for a girl to be with her father. And we all know daughters and fathers have a great bonding that they have between them, that she refused to come back. And what has the judiciary done? At the behest of the mother, repressed the child's emotions, deprived her and robbed her of that wonderful warm interaction that she would have had with her father. These children carry these baggages when they grow up as individuals. We have cases where they come up and they say, my father and mother were in a custody battle and I have seen what all these things are as far as my memory goes, and it has affected us and now it is affecting me in my interpersonal relationship. So it is a whole lot of aftermath that happens in these cases, but I will not get into it. But today, we should have a wake-up call, and when I say it's the judiciary, that is the lawyers, the judges, the legislature, and everybody concerned over here. And if the Law Commission recommendations, as Mr. Malhotra has said by Justice A.P. Shah, is not even looked into and not even considered, I do not know what we are going to do. And I think with utmost respect, populist remarks and populist statements in judgments which are there can lead only to further deterioration in these issues which are there. It is not going to resolve the issue. It's going to make the issue worse. Thank you so much. And please pardon me if I was a little sort of, how do I say, brutally honest about certain things. But I thought this was one forum where I could express what practical things happen in a trial court, because I do work in a trial court. And that's where is the origin of all these custody battles. Later on, it gets into legal argument. But these are the things that we can say. Then I think we will do justice to our children. That's all that we can say. Thank you so much for giving me this opportunity and this platform to express my views. Shyam, I really owe it to you.
Thank you. I mean, in fact, it was indeed a pleasure hearing you express your thoughts, emotions, and everything. But I just, before I go to Ramashan sir, I was just wondering whether who has to decide? We got a child here, we got a parent, estranged, of course, and should there be a legislation in place wherein we say that 1, 2, and 3 is equal to 5, or should it be left to the discretion of the individual judge, equipped, at times ill-equipped? Sir, Ramashan sir.
So really, it's an interesting topic, in fact, and that is required to be considered. Considering the manner in which this social thinking about family is going. First, as a judge, you are very well aware, silence for a long time will make too much of distance of the relationship. So the silence will have to be broken. How can it be done? Is the question. Who is the best person to do that? These are all the areas, because, say, as Mrunalini has rightly said, see, judgment law doesn't say that this is the way in which you will have to do with the, I don't even use the word custody. Normally, we use the word custodial rights or custodial this thing, regarding upon the right of a prisoner. Can you treat the child as a prisoner of a father or a mother? No, that should not be the attitude when you decide about the so-called custodial rights which has been mentioned in the Act itself, because we will have to go by the words in the Act. There is a whole difficulty. When you say that the mentally retarded or the insane has to be says as a mentally challenged, are we not expected to change the word that has been used in the legislation itself? The custody, instead of custody, some other suitable word which will be conducive for the purpose of deciding the issue in an effective manner. See, that is the first one I want to think about. Secondly, everything depends upon the judgment law doesn't say that you will have to decide in a particular way. Ultimately, if you read all the judgments, it only says when you are deciding about the right of the child with whom he has to have interaction. I will say instead of custody, with whom you will have to have interaction or with whom you will have to have association, then the question will be the paramount welfare of the child. That is the only law that has been laid down in, if you read from 1955 to 2022, none of the laws doesn't say that it is for the will and pleasure of the parents that will not be decided, but it is the welfare of the child. So what is the welfare of the child is always a question mark. How this is being considered by individual judges of the family courts or the courts which are dealing with these issues. Rightly you have said, but in foreign countries, the condition is the number of cases pending before the courts are very less when compared to Indian courts. So you will have to provide an infrastructure of increasing the number of courts to meet the issue as such. That is what is being said by the Supreme Court also in the Judges Association case, that number of cases will have to be increased for the purpose of meeting the situation. One. Secondly, as far as the training aspect is concerned, I am very much interested on that, because when you are training a judicial officer who are dealing with family issues, the training pattern should not be in the manner in which you are giving the decisions of the High Court or the Supreme Court and say decide on that basis. No, because as Mrunalini has correctly said, the courts are not the decisions are not saying that every decision is applicable on the facts of the case. Principle is laid down as to what are all the things to be done. That also in family matters, the Supreme Court several times said, we cannot give a straitjacket formula for how this will all be done. Everything will all be depend on each fact of the case. So these are all the areas where the family courts also will have to sensibly think about how the best interest of the child can be looked into for the purpose of deciding these sensitive issues. So that is one thing. And also, as you rightly said, see, I had occasion to deal with certain family matters when I was a additional district judge in Mavelikara, and also for some time in Tiruvandhuram. 2 occasions came before me. See, one case where there was an application for divorce pending for around 3 to 4 years, because by the time I went there, it was ripe for trial. I called both parties. I asked about the reason why they are not joining together in the chamber. Then I thought that there is no issue at all between them. But the only thing is she wants to go to the mother and live with the mother's house, because she is getting some, what do you call, the pampering, even at the age of, after becoming a mother of a child. The pampers that she gets from the mother's house, that much pampering she is not getting from the husband's house. So that is the reason she wants to be with the mother's house alone. Then I thought it is high time to call the parents of the both parties. I called the mother of the child, because father is no more, only his mother is there. I called the mother. I said, how long you will live with your husband? She said, sir, till his death we were living together. Then I asked her whether you don't have any issue with your husband. For every time you are coming to your house and your parents are protecting you. Then the mother immediately said, sir, my parents will not allow me to come unless I come with my husband. That is the immediate response of the mother. Then I said, if that be the case, why can't you use the same yardstick to your daughter also? When she comes, sort out your problem and come. It is not the place where we will have to keep you both away. We want to see that we have given in marriage only to see that you will have to live together, bring the children in a proper way. And I also told her, see, if that be the case, what will happen to the child? Whether the child will not be losing the right to have an association with the father. He is not entitled to get the same, what do you call, the shelling out the same type of love and affection to the child for her welfare or his welfare. Then immediately said, sir, I will advise my daughter to go. You don't believe, next day, both the husband and wife with the child came and told that, sir, we have sorted out the problem. We want to live together. I am withdrawing the petition. So this is the way in which, because the parents of the daughter or the grooms, I can say, they also got a greater play to do all those things for that purpose. And another case which I dealt with in Trivandrum was, the husband and wife were working as a nurse in UK. The children were also there with them together. They were living together. At that time, what happened was, the contract period or the superannuation of the husband happened. He said that I want to go back to our place because we cannot reside here. So I will go back. After your period, you also come back, because we have enough money now, because both were working for a longer period here. So we had enough money. We'll spend our time in India with our parents, so that it will be better for the children also to have the association with the grandparents. She said, no, you go, I will come back after some time. Quite unfortunately, that did not happen. And immediately after coming back, the husband thought that the wife is so adamant, she wants money only. And she said that I don't want her. And she started, a lot of litigations were there between them. By the time the wife's period is also over, she also came back. And after that, the wife wanted to join with the husband, but they may not be able to join because of the long separation that happened because of the living separately for a longer period. We interacted with them. There was no issues between them. Only thing is, she was so adamant, she did not come back. And not only that, some cases have been filed against the husband by the wife's people. Criminal cases are also there. I have been, I'm facing a lot of litigation on account of that. I don't want to see that. Then I talked to them. And I find that there was no issues between them. They want to join together. There is no complaint about their attitude or behavioral attitude also. Thereafter, I said this, when I talked to the children said that no, sir, we are living with the mother, I don't want the father. Then, because the girl was about 15 years or so at that time, I asked her, see, ultimately, suppose I am giving a divorce, and or as you said, as you like, you can go to the father or mother as you pleases. See, when you are a girl, when a matrimonial alliance is sought for you, when they talk about the background of your family, first of all, they will think whether this girl will be suitable for our family, because she did not know how to adjust with the in-laws if she was brought to their house. Will you think that unless you go for a love marriage or something, will you think that it will happen? Then I asked the child, the son also, see, you are also going to be a father after some time. Suppose your child or your child says, I don't want the father, I want to be the mother. What will be your feeling? See, that kindled a lot. Thereafter, they went back, they talked to both the parents. They become the good mediators for the purpose of resolving the issue between the children and the parents. And they came and said that, sir, we are withdrawing all the cases. And I said, lastly, I told them, see, it is your interest. You will have to decide whether you will have to decide together or not. It is your issue. Your parents or your relatives will not be with you for a longer period. They may be there for some time. Thereafter, you will have to be left alone for facing your problem. Then you will be finding it difficult to do with that in the society nowadays. So then they understood the issue. Thereafter, they came back and said, sir, and also said, if suppose husband does not want the relatives to come, keep it them for some time. That is not going to affect your relationship. After some time, you can convince your husband that no, they are not our enemies, so that both of you can both can prevent each other coming for some time. Your parents will understand that, and thereafter you can have a joining together. That can be possible, and you can have a good relationship with the parents also. That worked out, and ultimately they withdrew. 9 cases were pending between them from 2014, and thereafter they have resolved all the issues. They started residing together. Children were happy. They came twice, one on a Christmas day and on New Year day, with a cake for me and saying that, sir, now we are happily living. See, this must be the attitude of the judges also when dealing with the family court issues. Because if you say that your doctor expulsion alone is your criteria, that will not be possible. But at the same time, the courts are having their own limitations of giving time for these purposes because of the mounting number of cases before each court. But rightly said, I do not know because how many cases are being properly settled before a counselor. Is there any properly trained counselors to deal with these issues? It's a big question mark according to me. Because none of you see, when you go to the counselor in the family court, they talk about for half an hour or something like that. Thereafter, have come to a decision that they are not able to join together, go for a divorce, decide the other issues. This is the way in which things are being done. So that attitude of the counselors must also change. They must also have a counseling for the purpose of reunion, putting the child as a target or as trump card, I can say, when you play a card game or a trump card, to say that unless you settle the issue, the sufferer will be the child. The interest of the child, you will have to have some adjustment, or you will have to forget about your egos and other thing. So all those things can be possible once you have got a proper counseling of the parties in the presence of all concerned. It is not between the A and B, the husband and wife alone, but all concerns who are interested in the welfare of the child. So if that is this type of training must also come for the counselors in the family court also. Rightly said, the psychiatric, this clinical psychiatrist, because normally what happens is this is not being tried by or considered by a clinical psychologist. They go to the psychiatrist. There is a whole difficulty. Clinical psychology has not developed in India as has been done in other countries. So you will have to have a special clinical psychologists available for family courts for the purpose of dealing with issues, emotional issues and the sensitive issues And the psychological issues that is likely to come on account of the separation and the loss of affection of both the parents to the child. So the child must be the pivotal role for the purpose of sorting out the what you call the differences between the parents. For the purpose of the child, they must join together. Maybe some cases it may not be possible, but at that time you will have to go to the extreme steps. But most of the cases, according to me, if you sit together for some time, spend some time with them and understand the real issues, 75% of the cases can be settled amicably by reunion. And the child will be getting instead of a court order, they will be getting a better looking after facility, I can say, by getting sharing the
point well taken, sir. I mean,
the parents, the love of the parents. This is my view, that is the way in which we'll have to think about it.
absolutely.
Even if the law comes, law also gives some guidelines. If it is not suiting with the guidelines, that will go out, fizzle out. So these are all the.
Just to add to what sir is saying, very quickly, 2 points, Shyam.
Yeah.
I think rather than putting the blame on the judiciary and saying that the judiciary needs to work, I think charity should begin at home. The difficulty I see when I see an appeal or when I see at a high level, the drafting, the inputs, the petition, the draft is pathetically poor. So we have to first train the younger lot, the lawyers, to put it into the petition what a petition needs. Only if you put in a petition to a judge will you train the judge, will you equip the judge. So armed with your section 12 application for interim custody should be a parenting plan. The litigant says, I have a parenting plan. The lawyer says, forget it. It is not in the act. You will not get anything. So this kind of an attitude of the lawyers is the first thing we need to do.
Absolutely, sir.
And
yeah, of course, sir. Go ahead, please.
Is another issue, but this is important. Second, I'll just quickly make a one-line submission. As Mrunalini ma'am said, no visitation, no maintenance. Likewise, no maintenance, no visitation. It should be the rule. Now, with these two, I think, Shyam, it will be best if you...
No, I'm asking Vaibhav Sheth. Please, sir. Go ahead with your question.
Hi, thank you so much. I think this was a very informative session. A lot of fathers like us, wanted to hear what we heard in this session. This comes across to us as very refreshing. But again, the ground reality is, let's assume that I file a petition, right? In the petition, I talk about shared parenting, which is pretty much, in the best interest of any child, regardless of the age, right? How is the judge gonna take it as, does he have the right law to support him to approve a shared parenting plan or no? Or will he think 10 times before, deviating from what's written in the, the Hindu Marriage and Act or, the Guardians and Ward Act? And my second question is very important. It's a well-known fact. Any dispute involving children is synonymous with parental alienation, right? I don't see any any point in the law which actually treats parental alienation very harshly. We all know, the kind of emotional abuse a child goes through when he or she is alienated from one parent, be it the mother or the father. So how do courts treat that as? Thank you.
See, for that I can say, is there any bar that your parenting planning should not be accepted by the court?
Can I just answer this question? Sir, one moment. See, Vaibhav, I think I go back to what you ought to do. It is in the law. Section 12 says the judge can make such order for temporary custody. It is not said anywhere single custody, joint custody. It is you who have to present your case. And I think what you really need to do is tell the judge there is no provision in the law asking you to decide such order for temporary custody. It doesn't say single parent, so it can mean both parents. It does mean both parents, and it is in the best interest of the child. And cite Tushar Obale, cite Savita Rita Raman, and tell the judge, please pass an order. If the order doesn't come, go to the High Court and appeal. I think this is what needs to be done, is rather than asking for single. See, if you are deprived, don't ask for single custody, ask for a joint parenting plan. So change the focus. It is how you put your petition. And I think if you tell the judge it is not banned or barred, he will take it. Second, parental alienation, sadly, is not even looked at. Nobody bothers. It is not treated as a wrong. It is considered in India, it is considered an inherent right to keep the child and to retain the child and to parentally alienate. This sensitivity, as Justice Vijender Jain was saying, has not come. Third, the courts need to understand that parental alienation should not come because it is very abusive to the child. And we are seeing the proof. I have seen many cases where the parent who's the custodian teaches the child to abuse the other parent. It's very natural. And the child does it for the fear of losing the custody. So this has to stop. And the sooner we think of joint parenting and shared custody, where the child is in contact with both the parents, the sooner we can resolve this problem. Mrunalini ma'am may like to add to this.
No, so what I want to say over and above this is, I completely endorse Mr. Malhotra's views. Whether there is I think Vaibhav, your question was whether there is any specific provision in law or in the legislation as far as shared parenting is concerned. We are all talking about shared parenting. We're talking about parental alienation, but is there a provision in the existing provisions of law? To that extent, you are right that there is no such letter of law which talks about the shared parenting. And that is exactly why I said that there needs to be this training and training and sensitizing of the judges to go beyond the letter of law to understand what the spirit of law is. And that is why that sensitization is very much required. Secondly, I can also tell you as far as the parental alienation is concerned, I'm sorry to say, and with utmost respect, but this platform is giving me the courage to say this, judges are clueless. What is parental alienation? Some Greek and Latin? So where are they going to think on those lines and incorporate it? This all stems from their sensitization, from their grooming, and from their training that comes up. Today, these are the concepts, Vaibhav, which has come up over a period of time because you and me have access to overseas courts, we have access to internet, we have access to other things, and we have learned all these concepts over it. But today, unfortunately, I'm talking about the lower courts, and this is not about the higher courts. These are concepts which are non-existent. So that is when I said in my speech that there needs to be some kind of sensitization of the upcoming lawyers, some of the lawyers who have no access to such concepts and what the aftermath of it would be there. How there should be not only the training of a judicial mind, but the training of a lawyer's mind who specialize in or who want to work in all these things. It's going to be a combined effort to really bring about these changes from the age-old thing that A gets the custody and B gets to visit on a Saturday or Sunday. This is all that I would like to say. Thank you.
No, madam, no, just a minute. See.
Yes, sir.
Where you say that, see, the law is there, as Malhotra has said.
No, there is no law.
No. See, no. There is a reason why I disagree with you, madam. Because where it is stated, where it is stated,
such order.
No, that is the reason why I'm coming. Where it is stated that the joint parenting should not be given.
Yeah.
But is it any ban?
No, sir, not at all.
No, when there is no ban, because when you think about when you think about the welfare of the child, and if you feel that the plan that has been produced after discussion with the both parties, if the both parties can agree on that, what is the wrong in passing an order on that basis?
It will be tested.
We would be happy. But how many judges at the lower court, sir? And I'm really
no. That is the reason. No, that is the reason why I said, madam.
No, how many judges in these lower courts will have the desire to go beyond what the letter of the law is, what is written in section 6 or what is written in section 7.
Let somebody, I will move an application in the next case I get that such order means temporary custody means in the welfare means joint custody. Please disagree with me and pass an order. I will take it to the High Court, Supreme Court, settle it. Law will come. But ma'am, I am one with Sir Justice Ramakrishnan that there is no ban, there is no bar on joint parenting. parenting. It is an innovation. You have to read into the order. And Supreme Court says you can read down the statute if you need to. Shyam, I think you should get another question.
Anil sir, if I can just interdict.
Yes, yes,
It's
please.
not a question of a bar or ban, but
Yes.
to what extent we are proactive, to what extent we are doing this thing. And end of the day, you say shared parenting. It's like, I mean, end of the day, we are thinking of something, it says a shuttle. No, unless and until the welfare of the child is supreme, I don't think shared parenting is the ultimate answer for any of these things. I'm not very sure. I leave to this August assembly to decide.
Shyam, I understand what you say. See, now let me explain to you the American case which I did. What was the shared parenting plan? Father will not separate the children from the mother because the children are very small. Father will not stay with them. Father will visit them on day 1, day 2, day 3, between these hours to these hours, and contribute to the child. So you can actually work out some sharing, some involvement of both the parents without physically moving the child. So it is for the lawyer and the court to see how best you can put a plan. You are not making a child move from place A to B. If the child is very small, yes, child should.
And sir, end of the day, like Rameshan sir said, the culture difference, everything has to.
No, but Shyam, we have changed.
We are not talking about US or UK wherein
No. Listen, this is a problem in a lot of Indian homes today where both parents are literate and working. Mother goes to work, she leaves the child with her mother. Father says, when I am sitting here, my parents are sitting here, why can't I have access? So you have to think on a case.
Perfect, sir. Let us hear from Viber saying. Viber, what's your story?
Thanks. I think I had a very good view. Sorry, I did not mean to stir up the conversation.
Oh, no, it's a good thing. Only if there are two extreme views can we have a balanced view.
And I fail to realize why isn't the legislative doing something about it? I know there was a shared parenting PIL way back in 2019, which the Supreme Court kind of appreciated it. But then I think the judiciary is tied to, right, when the legislative does not do anything about it. So how can we push them to, bring about this, debate this in the parliament and,
See, the answer is very simple. I have tried it in 2 or 3 cases. Last case I tried in Aman Loya where the father had taken the child abroad. I have told the court, please lay down practice directions. Please lay down guidelines, which will become law after some time like Vishaka. So to make the awakening call for parliament, you have to go via the judiciary. When law is not coming in, please ask the Supreme Court to lay down some sort of guidelines. Well, Justice Lukur did it in Surya Vadanan for interparental child removal. It was watered down. So we have some sensibility now at least. But at the same time, the answer will lie with the Supreme Court now. What Supreme Court will say will become the law after some time in the shape of the legislation. So till the awakening comes, see, Law Commission has done its job, Bindal Committee has done its job, the reports are there, but there is no proactive result. Now, till law changes, till something happens, we can't be stuck in this quagmire. Either we start at the family court and we read down section 12 and we start from the bottom, or we start from the top. I think both ends need to be ignited. So, Shyam, let's open some more questions so that we can have some more.
No, I just wonder, what the thoughts of Mrunalini ma'am would be on this one.
Yes, sure.
No, I am just saying that it took a Supreme Court to lay down guidelines in Vishaka for the, as they were saying, that's protection of women from the sexual harassment at the workplace, where in 2013, those guidelines have become an enactment. So today we have a full-fledged thing. Where is the origin from? Sexual harassment at workplace didn't exist in the past. Of course it existed. It was only when in the Vishaka guideline that it came in. Then came the Nirbhaya and that came the Verma committee, and then we have an act in place. So something of those guidelines, if they are laid down by the Supreme Court, for example, in the maintenance matter, in October 2020, Justice Malhotra has laid down guidelines as far as the maintenance to be granted. So when should it be granted? How much should it be granted? And what are the essential conditions? Today, that has become a law of the land. The lowest court in Bombay, whether it's a domestic violence court or a family court, is following.
Ma'am.
Yes. Sorry?
Ma'am, to inactivism and wherein the judiciary should step in.
Sorry, I missed you. There was a.
You broke. So you
I'm sorry. There is some sort of what do you call legislative inactivism wherein the judiciary should step in. Judiciary which does not represent the people.
I understand.
Not that, see, there I differ from you, because most of the laws come, see, for example, ragging. Not that ragging was not there. Ragging was there even prior. But when it reaches a stage where it is become intolerable, the law intervened. The Supreme Court intervened. A committee was appointed. With the Raghavan committee was appointed. He gave a report. On that basis, they are given certain guidelines.
I bow down to you. I fully agree with that.
Just wait. Not that. Just wait. See, the judicial, it is not a case where everywhere judicial legislation is the result, or judicial legislation is the rule for the legislature to do their work. Not that. But in a cases where it is really required for the purpose of the protecting of the society, that must come. One. Then ragging. Thereafter, another. As regards your this thing, what do you call the custodial protection? All these cases came because of the Gatra. 1, 2, 3, 4, 5. Then the regarding arrest came by Basu. Thereafter, CRPC was amended. Certain guidelines were given as to how this will not be dealt with.
Sir, this being an academic platform, I'm just requiring or requesting that why should we give them so much of freedom that you sleep? The judiciary will take care.
Because they have been
See, Shyam, I will put it very bluntly. There is constipation in the legislature. You need a laxative. So let us see what we did in adoption. Inter-country adoptions.
Too much of laxative at times is the problematic, sir.
Sir, the legislation is
What did we do in adoptions? Supreme Court laid down Lakshmikant Pandey 1, 2, 3 adoption regulations.
Correct, sir. Correct. I mean, I don't have any quarrel. I don't have any conflict.
Therefore,
my issue is the
child removal. We first need to identify child removal or child custody as a parameter of a law. If we can't do
absolutely.
Guidelines. Let's take a given case and let's lay down guidelines. Let Supreme Court say these are the guidelines for joint and shared parenting. Let family courts take a cue from it. Let it go to the judicial academies. Let the family court judges be trained.
Not only that, sometimes legislature may be thinking that it is a so sensitive issue, or it is a secular country where this can be possible or not possible. When certain guidelines were given by the higher courts as how this will not be dealt with, probably that may give a clue for them how a legislation will not be drafted on that basis. Probably that way you can take it.
Sir, my only area of difference is that we live in a democracy, and when a democratically elected legislature is unable to legislate, is it for the minority with whom the people has no connection at all? I'm sorry, I have connection because I'm a lawyer, but to say that this is the law.
Depend on the answer. If you depend on the parliament for anything, then it will be eternity.
Sir, then you got a problem with your constitutional rights, not otherwise.
I have an issue. If the parliament is or the government is so engineered or empowered that they want to change the age of marriage, why can't they look at child removal and parenting issues? What is the fire in changing the age of marriage? Our homes.
Sir, it all depends upon who is going to vote and how is somebody going to vote.
What I'm trying to say is the dire need of the day is for guidelines to be laid down. If the parliament is not coming forward, let the Supreme Court lay down guidelines in a given case. Let the path be shown. Let there be clarity. Once a Supreme Court judgment comes, like Justice Indu Malhotra's judgment on maintenance, which is again a path-breaking judgment, and family courts are following it, particularly with the flexibility of the family courts. The family court, the lawyers being trained, I think it is a joint coordination. It is a tandem exercise which requires lawyers.
Correct. I fully agree with you, sir. Let us hear from Deepak Pant. You got a question?
And one thing, Judicial Academy's role in training the family court judges.
Deepak, go ahead.
Can you hear me okay?
Yeah, go on, please.
Yes, absolutely.
Yeah. Very small question. Is there a jurisdiction on shared parenting across the high courts in India?
No.
So Justice Amarnath God, he was in this Telangana High Court, and now he has gone to Tripura High Court, and then he has been, giving shared parenting orders. Fathers are going gaga over there. Unfortunately, I see in Bombay High Court, I've been told that because of Tushar Obale ruling, a parenting plan cannot be enforced as a rule. Okay. So what has happened is, in my case, my judge, who started the shared parenting in family court, he passed an order for shared parenting, and then later on he said that because of Tushar Obale ruling, parenting plan cannot be enforced as a rule. So just want to understand, are there any regional jurisdictions or nuances that we should be aware of?
I don't think, Deepak, there is any bar. Rather, there is a promotion to it. So you see the latest judgment of Savita Sitaraman of the Karnataka High Court. See, the roadmap is before you. It is for an individual judge. According to my interpretation, there is no provision in the Family Courts Act or the Guardian and Wards Act or the Hindu Minority and Guardianship Act which imposes a ban. To the extent family court is free to design its own procedure, it is equipped to read down the law. It is equipped to do away with the technicalities of law of evidence, law of civil procedure. So it is on the family court. It is or a family court judge. No high court judgment lays down a ban. Least of all Tushar Obale. Ma'am Mrunalini may be more equipped to deal with Tushar Obale, but I don't think Tushar Obale lays down a ban. It says there should be an endeavor. That's all.
Yeah, but that's a very, it's just expressing a view that does not become something. And then at the end of the day, it is only the Supreme Court who can take, as I said earlier, that you needed a Vishaka guideline to bring an act into place, which is a sexual harassment at workplace. So some kind of aggressive stand taken by the judiciary. Shyam, I agree with you that this is a job of a legislation.
It's an exception. It cannot be the rule. I mean, if the court starts legislating,
what do
end of the day.
What do we do if you have incompetent legislators who have no time to think about it, and they only have time to think about conversions and other age of marriages, which is not so important than something which is dealing with as tender as the mind of the child? I mean, if the legislation doesn't know what its priorities are, I think all of us are just wasting our time. And that is what the reality of the day is.
You have a tire which is gone. You need a new tire. There is no new tire. So you will get a puncture. You will get it retreaded. So what I'm suggesting is, let the puncture and the retreading be done by the Supreme Court till this Parliament makes a new tire. That's it. So what I'm saying is, if Parliament is going to sleep for the next 50 years, should we die? Should we live with this misery? Why can't the Supreme Court innovate? Well, if Justice Indu Malhotra has laid down guidelines on maintenance matters, because maintenance is so loosely worded, but she has laid down guidelines and every family court is following. Why can't we do it for shared parenting? That is the question which I ask myself. I agree.
Wonderful. We have another question coming up.
I agree with you that this is not the job of the courts to legislate. But then if the Parliament is failing, should the courts also fail? Or should you only do matters which require publicity? No. I think the answer is we have to evolve. Law has to evolve. Why have we made all these judicial academies? What for? Why can't we train the judges?
I agree with you, sir. We have sir, can you identify yourself? Let me. You can unmute and please identify yourself.
Yeah. Hey, this is Arun Kumar. So right now I'm fighting a custody case for my close to 7 years old child. He is like suffering from autism. He's an autistic child. So he needs like a constant speech therapy and occupation therapy and everything. So my wife, she is residing in her hometown that lacks. It has facilities, but like very, very minimal facilities and all those things. And at the moment, she's not even giving these therapies to him. And I have complained multiple times at the court, and even there is an interim custody order for me to have the child for and on the first and the third Saturday and Sundays, and and it has been violated multiple times as well. So my question is like, whenever the other parent like violates the order, And even in the progress of the case, it is being a medical condition for the child. He is not being provided the needed therapies. In spite of complaining at the court multiple times, there seems to be no action at all. As a father, it is like very concerning, and I'm unable to do anything. So they just the other party simply comes to the court. Oh, no, we are giving the therapies. But when the time came to produce the documents as part of their the trial, the respondents' evidence and everything, they didn't provide a single medical record on all these days, whatever they provided. So I so and the court is of a very I shouldn't say this, but it has like a very prejudice. Oh, it is the mother. Oh, how will she not do such things or do care these things? That mindset is always there.
Sir, irrespective of your question and not my commission on this platform, I'll ask LG to reply to that.
I have understood your issue. I think what you need to do is you need to do something radical. If I were your lawyer, I would take the matter in a habeas corpus to the High Court and say, the court is the guardian of the child. Kindly ensure that treatment is provided by either giving me custody or telling the district magistrate or the superintendent of police to ensure that the treatment is given. Such like extreme relief ought to be thought to create some sensitivity in your matter. I understand that the family court is perhaps totally insensitive to your issue. The problem is the gender fixation that the mother can do no wrong or the father can do no wrong is probably too ingrained in the mind of the court. So to destroy that myth, that halo, you have to do something like a habeas corpus and say to the court, this is my evidence, these are pictures, this is the neglect. Please issue a commission, please send the district magistrate, please send the superintendent of police, please have a court report and dismiss my petition with exemplary cause if I'm speaking a lie. I think you need to do something of this kind. I hope that possibly
that ought to clarify the issue. Yes. And is it?
Yes, sir. So okay, yeah, I'm not sure because the child is with the mother. I'm not sure whether a habeas corpus will be entertained or.
You are not seeking custody. You are going to ask court to invoke its parents portray jurisdiction to ensure that the child is getting treatment, the child is getting the medical requirement because the child is autistic, produce evidence that there is no facility for an autistic child to be treated there. Say, I'm not seeking custody. See, habeas corpus is not for custody. Habeas corpus is parents portray for the welfare of the child. You may carve out your relief in a way to say, give me access, give me visitation, provide the medical facility. If you have a sharp engineered judge in 226, you can do it. You see, if you keep sitting in the family court, you are going to go nowhere. So, Shyam, we can move on to the next question. Please.
Absolutely, absolutely. I mean, CSG, I don't know what it stands for, but please.
Can you identify his full name?
Yes, sorry, sir. I'm in a very dark area, so lighting is a problem. My name is CS Gupta. I'm calling from Delhi.
Yes.
And I do regularly listen to Malhotra ji and get a lot of knowledge from him. But my own problem is that the sensitivity in the lower courts and high courts is completely missing, except for a few exceptional cases. I don't wish to discuss my personal case. I have a daughter. I have not seen her for more than 5 years, in spite of a so-called order, which is 2 hours a month. But that's my personal case. I don't wish to discuss. The attitude of the lawyers and the judiciary is horrible. As a father of a daughter, I'm actually horrified. The way they deal with the situations. That is whether there is no such law which says that the parents or the judiciary or any member of the society has to promote parental alienation. And it's a simple common sense. There's no such law. There is no constitutional guarantee which says, yes, we have to ensure parental alienation happens to the child. There's no such law. And even visitation orders rights a completely flexibility that can be discussed also. No discussion takes place. There is a few minutes discussion and cases hang fire for ages. That is happens not just with me, but with most of the cases. And the only thing the family courts are interested in fact, during the COVID pandemic, I saw a order both in the Bombay court as well as the Delhi courts for the family court strict guidelines. If mutual consent divorce is done, then alimony has to be paid and we will readily accept the applications. That's it. They are simply the basic act. If you read Family Court Act, is for resolution of grievances so that family doesn't get breakdown. That is part of the Family Court Act. But the entire family court machinery is being governed more by family separations and money for whatever be the reasons. The priorities are completely different.
Just give me a second. We have
Yes,
got Mrunalini ma'am here. Your caustic remarks about the system is really wonderful in the sense like, I mean, it should be an eye opener, but end of the day, is it that? Please, ma'am.
Sorry, I didn't get your question, Shyam.
No, Gupta sir was saying about the way in which he has been,
Yes.
what do you call, not properly handled,
Yes.
or rather, he didn't get the requisite relief from the court. But end of the day, when we work in a system, there are certain parameters, right?
Absolutely. So there are certain parameters. I think the purpose of this webinar, Shyam, and which you have taken the initiative, is to bring about some kind of a message that we want to give it. That yes, when you are dealing with within the sort of folds of the law, especially with relating to custody issues, how is it in the interest of the child to keep the child away from the other parent? Now that itself,
Ma'am, we'll just ask Gupta sir directly what the exact issue is.
no. So if whatever maybe, I think he may be having a more detailed think about it. My only concern here is that today the existing laws and the infrastructure as far as issues of joint parenting is a very far-fetched thing. Let's be very practical. But even giving access to the father to be able to give the child the best possible treatment who's an autistic child. Now, these are the basic things which have not been, I don't know which cause they are happening, but I'm sure there is a reason why it is happening. Now we are dealing with such issues. This gentleman, the father, has not seen his daughter for the last 5 years. I mean, are we really in a banana republic? Or is this a jungle raj? That the father is not able to see the child? However good, bad, and no offense meant to you, sir, I'm just giving you as an example that it can be there. If you cannot let the child meet outside, do it under the supervised jurisdiction, supervised in a supervised manner, before a counselor, before a court officer. But you can't debar a parent from seeing a child for whatever reasons may have been there. Of course, these are two extreme cases. Probably I find this is not really the norm. The norm is that the courts are giving visitation order. The process over here that really needs to go is that should the courts go beyond a visitation and a access order to make it more in the interest of the child, to make a role of a father in the child a very living, ongoing, present, continuous process rather than something which is there in a textbook. I think that's the underlying thing.
Absolutely.
Just to add to it, the bottom line is Mr. Gupta's case is an eye-opener. One, what are we doing about it? And two, is there a solution to it? And three, are we going to do nothing about it? Let the sleeping dogs lie. Let Parliament sleep. Let us all go to sleep.
No, recently, I think the Kerala High Court has given a guideline as to how the family court will have to do with the disposal of cases in family disputes.
Sir, but until and unless it comes from the Supreme Court, Kerala High Court judge in Punjab analysis is not binding on me. So Mrunalini ma'am is right. It has to come from the top.
It has to come from the top. There has to be this tongue which comes. The gavel has to be there.
Justice
On
Midra
the lower courts.
on maintenance led to so much confusion that people stopped reading them. Even Delhi court started refusing to comply with them. And
Sir, I'm a trial court lawyer.
I was privy to access to some assistance which I had given to her. And I think it's being followed simply because what the Supreme Court says is law under 141.
Yes.
So unless it comes from the top, it doesn't happen. And anything coming from the Supreme Court goes to the academy, judicial academies, and it filters down to the state academies. So it has to come from the top, otherwise it won't work. And Shyam, either you become an MP and do something.
We will vote for you.
Can I
We will
share
vote for
another thing? Can I share another thing?
Yes.
Yeah, definitely, sir.
Okay.
Sir, please.
I have no issues that the child is with mother. She is a daughter, and she
you. No,
definitely.
I understand. I'm saying visit for you.
Yeah. Now, this is what happened in the Delhi court. A particular judge, in front of the entire hall of 50 people, without listening to me, started blasting me and telling me he spoiled the decorum of the court. He said, "You will never get custody." I was puzzled. I said, "I have not even applied for custody. Child is with mother. I don't have any issues on that. At least there is no third party interference in that. So I have no issues on that. I just want to meet my child. That's it." He says, "You don't get custody." This is how the cases are being twisted. Right?
That's where, I mean, the core of the discussion was, in fact, whether it should be subjective or objective justice. One. Number two is that should we relegate it to individual judges whom we assume has got so much of wisdom? Of course, I mean, the judges and the panel who are here are having the wisdom, but still need not necessarily be so. But end of the day, when it comes to these issues, this has to go elsewhere, not to this. I'm not sure. Mrunalini ma'am.
Not by the Shyam, even if it goes to elsewhere, ultimately who has to implement it?
No,
Yeah.
that's, I mean,
Who has to implement it? You have to come to the court of law only for that purpose.
that's all correct, sir. But sensitivity issues, unless and until you are sensitized, how do you deal with this thing? I mean, and what is the guarantee that just because you're a judge, you are sensitized? I'm not very sure, and I'm sorry also.
The Shyam, I think first you have to get rid of the gender fixation. You have to get rid of that ingrained mind in your concept that it is the mother or the father. If the mother is working, the father is not working, or if both are sitting at home in COVID times, why can't you have shared parenting? Why should the child always go to the mother?
Sir, I mean, Anil ji, my issue is that shared parenting is all good, but end of the day, you are trying to bifurcate, or I'm not very sure. I'm not. This concept is alien to me, but it's wonderful. But I'm not very sure. I don't know whether Ramashan sir will agree with me. But when you say shared parenting, how come you are so sure about these parents are so good and so beautiful that they'll share it?
See,
Not that Mr. Mr. Shyam, there arises.
The problem is, I think, let us now see, you have a good standing, you are exposed to all kinds of laws, but even with due apologies to you, at your stature, you think shared parenting is an alien concept, it's an imported concept, it can't work. Let us look at the ground reality. I agree with you, it may not work for a certain strata of society, but where it works, why can't it come in? What is wrong with it?
Absolutely. Let it.
So inbuilt abhorrence or inbuilt rejection outrightly to say, no, it can't work. It's not possible. Where is it?
No, sir. No, sir. I was saying that let it not be the yardstick or let it not be the benchmark. It can't.
Lord Mr. Shyam, even in a family court, ultimately, what is the criteria that is being taken? The welfare of the child. If you say that paramount criteria for the purpose of deciding the custody issue is only the welfare of the child
need not be shared parenting. It can be individual parenting.
That depends upon. See, suppose you have got evidence to show that sending to the parent, the one parent, is detrimental to the interest of the child. If there are evidence to show that that is not possible at all, well and good, the court can take it. But as Malhotra and Mrunalini has said, there are possibilities where this can be developed. Why can't we deny that possibility is the only question?
Absolutely not, sir. I mean, I was only on the, what you call, bringing out of a legislation wherein you mandate.
See, there is Article 19 of the Guardian and Wards Act, which says, unless and until you are unless you declare a parent unfit, you can't take away custody from him. He's a natural guardian. How can you?
No, that is what the Supreme Court also said. Why do you deny parentage to the father?
Therefore, forming a concept that only one parent can look after the child, you are getting stuck in that quagmire, that quicksand, and you're going deeper and deeper. You see, you should look at the child. Only if the child is loved by a mother and father. Why have we signed the UNCRC? Why have we brought in the definition of the best interest of the child? Ideally speaking, for a home, a child needs a father and a mother. There is no child which can be brought up by one parent. Plain and simple. I think single custody should be an exception. Joint parenting should be a rule. Read down the definition of the best interest of the child. Read down the word such order for custody. Don't misread the fact
and you want the judges to decide what is best for the child.
Yeah.
Wonderful.
Shyam sir, may I come in, Shyam?
Read the case.
Yeah, why not?
No, if you can know, Mr. Shyam, if you
What?
can decide, no, if you can decide yourself about the welfare of the child, you would not have come to the court at all.
Not come to court in the first place. Correct, Ramakrishna sir. Shyam sir, here there are two adults who cannot live together. But where does it say that they cannot take care of their child together?
Bad husband, bad wife, but good parents.
They're good parents. So that needs to be given, that possibility also needs to be looked at, Shyam sir.
So
You can't just leave it in thin air. Yes, I agree with you. Why should the court do it?
Not that, not that. See, the law is there. Only question is, when the change of circumstances happen to society, how far that can be within the law you can provide it. That is the only thing.
See, Mr. Law is very
Like
right.
divorce itself is a foreign concept.
The father
Because
and
it was
mother
till
can't
death
see-
do us apart.
can't see eye to eye. They can't live together under one roof. But they love the child fiercely.
Correct.
And the child is very happy with both of them. So the child wants quality time with both of them. That can work. Why should you look at a child custody dispute as a test of personality of the father and mother? Why should it be the requirements of the father and mother? Why should it be the bad points of the father and mother? Why not the best interest of the child?
Shyam sir, I'll give you an example. My best friend going through a divorce, child is with the mother. When Bombay was flooded for 3 days, they had no food. The father came to know, and he drove down 30 kilometers, waded through neck deep water, carrying food for that child on his head. That is the affection the father had for his son, but he couldn't meet the son. But we had to give food, so we go. Ultimately, the father may love the child, may not love the wife anymore.
Now, sir, I mean, we are not on the emotional platform. I was just
No,
only
I'm not,
saying
I'm
that-
not talking of the emotional platform, sir. I am saying we have to
No,
consider that
Sam, you are
if
forgetting
the
a fact.
adults will not get along together, but for the child, they may do something good.
Rao, when you dealing with the family issues, emotional issues also will come into play. See, that is the reason why when we go to the matrimony, the mediation, you are thinking about the emotional stress also. When the emotional stress of both parties are taken care of, and if it is insecuritization, that insecurity that has been pointed out by Mrunalini madam has been taken care of, then both will come to a settlement.
See, I give you an example. Shyam, last litigation ended where there was an amicus. The father and mother fought. The petition became 5,000 pages. The judge said, listen, I tried 15 times, it won't work. He says, I'm sending the child to a hostel. Both of you can visit the child in the hostel. None of you are fit to hold the child. So this is the kind of threat perception you have to hold out to the parents. And I told the judge, not a word of what is written in the two petitions is worth it. It's cameras, detectives, and bad qualities of this parent and that parent. They're not even talking about the child. This is the problem with the issue when a litigation comes to the court.
Correct. I absolutely agree with you.
Like a divorce case. So you are more interested in settling your scores via the child.
No, even in a case where drunken father will be loving the child and the child will be more happy with the drunken father also sometimes. We can't say that.
He's happy all the time like Shyam.
Anil ji is a master of that. I'm not on that. But I'll say that read me. Who's that? Please,
No, it's
can you
already
go ahead with your question?
7:15, Mr. Shyam.
Just 5 minutes, sir. 5 minutes. We'll just finish it. And I'm sure that Mrunalini ma'am will suffer us for 5 more minutes. Yeah.
Yeah, I really appreciate all of your valid points and everything. I just this one more question. In a lot of family courts, right? I know that emotions come into play, but sometimes, right, more weightage is being given to the emotions. The mother being a female, she comes and cries in the court. But when you inspect the material facts and evidences, what she produces, it is like contrary. It is like extremely opposite on of her reaction and how she behaves with regards to taking care of the child and everything. So the court really has a very soft corner on the mother, and it is always of the fact that, oh, she cannot do anything wrong, and in spite of providing so many evidences or something, the fathers, they don't have really like any solution left rather
Sir,
than
sir,
to
sir, sir,
go with
you
luck.
cannot
No,
be
all
more
those things
wrong
are
because
pending.
we
No,
have
pending. No,
Rameshan
pending.
sir,
Pending matters. We
we
cannot.
have all these persons. No. I mean, end of the day, it's the welfare of the child, and the way in which they look into it is very, very clinical. And I'm sure that the existing legal system is wonderful. If you got a grievance, because it's our personal grievance, not against the system.
No, system can do the best. The laws are there because as far as India is concerned, there is no dart for any law or any position. But only thing is within the definitions provided therein, within how you are interpreting in a harmonious way for the purpose of implementing the intention of the legislature in making the law, then all your problems that has been raised here can be solved to some extent. I can only say because most of the cases, all the cases cannot be possible.
Correct.
But this can be possible, and this is a one way, and mediation is the one best. Mediation, when it goes for the mediation, you can go have a the psychologist, or even a best counselor for the purpose of protecting the interest of the child. There also specialization is required. The persons who are dealing with the family issues, a psychologist who are dealing with family issues, as a counselor who is dealing with family issues in an effective manner, those help of those persons also will not be required. Otherwise, it will be a counterproductive.
Last question. Can I ask you a question? Shyam, can I ask you a question?
You should.
Why are all your participants men? I brought in Mrunalini ma'am thinking there will be lady participants. So, but
And end of the day, how do you decide that they are all men? Like, I mean, there's some sort of gender, distinction available to you. It's really unfortunate. These are all females.
No, if you apply the Ardhanarishwara principle, man and female are there in one person. See, only thing is how will you express it, how will you exhibit it? How will you exhibit it? That's all.
I was reading the names. So unless they have changed.
No, I mean, what is in a name? Let us ask Suman. Suman sir, can you unmute and put your question? You put your hands up. That's why I'm asking you. If you're possible, please. And Vikas also, please.
Yes, sir.
Yeah, go ahead.
Yeah. So as Anil sir and Mrunalini ma'am was
Don't
saying,
say you are a male or female.
my voice says I'm male.
No, don't say that. I mean, Anil sir has got a problem with males and females.
So as sir and ma'am was saying that the direction may come from the top, means from the apex court, but we have seen in recent times that since the Yashita Shahu order came regarding the contract rights of everyday contract rights, apart from visitation right, should be there. But we see that in family courts, the contract rights are not given in that much importance, right? So the everyday contact is not given. I mean, maybe just once in a week or twice in a week. That way things are going on. So I think even if there is some perspective or some order is given from the top, or some maybe some viewpoint has been expressed by the apex court, I think that is not implemented on the ground, or maybe the litigants may not be able to voice their opinion before the court.
Now, as far as Kerala is concerned, I can share that once a case is listed for trial, day-to-day trial is ensured. And after the evidence is over, probably some time is given for the purpose of argument. That can be possible, it depends.
Yeah, Anil Ji or Mrunalini Ji, I mean, what's happening at the end of, I mean, we are comfortable with Kerala.
No, so what is happening? I think what his main concern is that why can there not be guidelines from the center, from the highest court with regards to whether having the contact, that is the visitation with the child, say for only once a month. For that, I would like to say that the courts are not going to get into individual cases and get that. They can only give a broad-based guideline, the higher courts, which could serve as a guiding principle for the lower courts to decide the fact. Now, each case, the individual judge will have to decide on the facts and circumstances. It would be unfair to say that he has to follow that, in a very blind manner, because he has to take the facts of the case, the age of the child, and certain factors into consideration. But what we are here is on a larger issue, and Mr. Malhotra will agree with me on this, is that unless this ball is set in motion, and it is these webinars or through some applications made to the court, this concept which we're talking about, shared parenting, more rights, forget the terminology, forget the words that we are using. We are saying give the child the love of both the parents, full stop. That's all that I'm saying. Let him be flooded with love from the, why not grandparents to see the children? Why should they not be given? Grandparents are the most loving creatures and they have a great bond with it. But today, this concept has to evolve, and the courts have to make it in a way mandatory, that rather than making it in a very clinical manner, this is what it is. Today, we have just set the ball in motion. I don't know whether in my lifetime this could become a practicality or not. But I can surely say that unless we make the first move, individual cases, the courts will not be able to have any guidelines, is what I'm saying. I think we are on a larger picture and we are on a larger issue at a very macro level rather than an individual level.
So Shyam, here I would like to give an input. I think we need to get rid of the word visitation. The word visitation is coined in a context where a person goes to see somebody in prison. Now, the word visitation is not used in the Family Courts Act, is not used in the Guardian and Wards Act. Now, what is the word used in the Family Courts Act? The words are custody, access, or guardianship. What is the word used in the Guardian and Wards Act? It talks of interim custody or access, temporary custody.
Absolutely.
So, first thing, we need to change the word from visitation to parenting. Once we change the word to parenting, the culture of joint parenting, shared custody will automatically come in. This
so the difference of opinion comes there. Joint parenting, you assume that both parents are responsible
because they're natural guardians. That title, that crown of being a natural guardian gives you the right of being a parent.
No, Mr. Shyam, sorry for the interference. See, when you say there is a joint responsibility for providing maintenance to the child by the mother as well, the earning mother as well as the father, why can't the same responsibility be there for the purpose of looking after the affairs?
That's all monetary thing. But when it comes to
see, you are only on the thing on the monetary. Monitoring is also one other thing that is required for the welfare.
Duty, responsibility, and rights come on the same platter. You have a right to pay. You have a right to be.
Sir, can we come to a conclusion that we require a legislation which says that there should be joint parenting?
I think till it comes, it can be read down.
No. Do you want it or not?
Yes, ultimately. See, Justice A.P. Shah has already given a draft of the.
No, sir. I'm asking Anil Malhotra. I'm asking Mrunalini ma'am. I'm asking Ramashan sir. I'm asking you individually. Do you want it?
Well, it has to happen to have a recognized statutory mode.
Yes.
You have to change the wording to make it more clear. But till that happens, how do we carry on? We keep waiting for that day 50 years henceforth. I know that is the ultimate answer. I am not looking at the ultimate answer. I am looking at the answer as of now. See, Shyam, I agree with you. You have to change the law. Justice A.P. Shah has changed the law. The Guardian and Wards Act amended. The Hindu Minority Guardianship Act amended is in the bill, is in the report. But who's looking at it? You want to change the age of marriage. You want to decide who will eat what. You will decide who will marry how. But you don't want to look at the child. So therefore, if you are not bothered about the child, let us do patchwork. Let us do the puncture. Let us reiterate the tire. Let us read into the words and let the Supreme Court lay down guidelines. And
Wonderful, sir. Let us do the puncturing work and
maybe Shyam's son will do the next seminar in the next.
Shyam sir, look at it the other way. Shyam sir, look at the.
I'll come back to you. 1 second. Mrunalini ma'am.
No, my only thing is that I think platforms like this provide a sort of an opportunity for people to voice there. Now, today with so many, I would say fathers, and most of them were or all of them were fathers, we have realized that what are their sort of difficulties when they go to a court of law, and how helpless they feel standing there as if they're like a prisoner or the accused and things like that. Today, the mindset of the judiciary needs to be changed to accept that there is no accused and there is no perpetrator in custody battle. There are two really loving, exceptional cases, of course, that there are two really loving parents who are there, and the child needs the love and affection of both. How can I, as a judge, ensure that the child gets both this? If this is the thought that a presiding judge takes into the mind and he decides, I'm sure we have made a great progress in this, rather than saying, oh, the Supreme Court has said in this, the law says this. If this is how you're going to do it, then there will not be any mindset change. But this application of mind, application of what the things are, and then setting the thing, it will be, okay, tomorrow it may be struck down by the higher court because it is not there in the law section. We'll deal with it. But this is what the lower court judge feels. I think we would have made a great beginning.
Perfectly right. Perfectly. I mean, that's something I would like to hear, but how far
because Mr. Shyam, a good law will come unless the lower court commits mistake.
Exactly.
Or supposed to be a mistake.
I agree with you, sir. Let the lower court make a mistake. Maybe there may be one trial case which probably may the person may suffer, but then the rest of the children will not suffer in future if the higher court takes.
Just to add to this, this is what the Judicial Academy teaches magistrates, trial court judges. Make a mistake, write a judgment, wrong or right. Supreme Court doesn't lay down the law. The trial court lays down the law.
Yes.
It is being affirmed or ruled out. That's all.
So, Shyam, ultimately, it is the judgment of the trial court or the high court in appeal or in revision, which is the law. Now, in Bombay High Court case, the latest case which I was just reading out to you in Delna Khambata, Supreme Court has not laid down the law. High Court has laid down the law.
Yes, High Court has laid down the law.
What has the Supreme Court done? Supreme Court has written a one-page order. This is not the law.
Yes,
yes. We dismiss the appeal. So law is, so the Supreme Court judgment, the High Court judgment has to be read as the Supreme Court judgment.
Yes, that's what is happening.
That is what is happening. So I think the homework needs to start in the family courts. And there I think the judicial academies should get up. This is a wake-up call. They have to start energizing the judges. They have to start training them. They have to start training, having progress. See, we have exploded into a family court litigation, but we have not equipped our judges. We have not trained them. We have not led them in law. How many people other than me and Nalini ma'am know the latest law at our fingertips? Very few. And Shyam is still stuck with men and women.
Absolutely correct, sir. Absolutely correct.
And by the way, even Mrunalini ma'am sees only men, not only me.
Sir, if we have to conclude the session also.
Yes.
That's another story. Ramesh, sir, your comments.
No, see, ultimately, no possible relief can be denied merely because there is no law. Let the law come. That is a different thing. With the existing provisions, whether anything beneficial to the child can be possible, that will not be explored by the trial court judges on the basis of the facts and circumstances, and also on the basis of the decisions laid down. But you may not be able, you will have to distinguish on facts, because the law laid down is the law. You can't say that law is wrong, but the law laid down is wrong, but you can distinguish on facts, and possibly you can provide relief to the parties in the way in which the parties are wanted. That is the reason why people are coming to the court also. Not the purpose of saying denying an application, rejecting an application or not. It is a relief, especially family court cases are concerned. They come for a proper relief. What is the proper relief has to be evolved by the judge on the basis of the facts and circumstances with the existing law till the law comes. Let the law come, because law may be required for some times. Let the law come. But till then, the relief required for in the best interest of the family and also for the child, that will not be provided. That is my view.
Absolutely, absolutely, sir. And when we come to the end of the session, can I have a parting shot from these two dignitaries, Anil Malhotra sir and Mrunalini ma'am, please.
Train the lawyers, train the judges, cut off maintenance if there is no visitation, cut off the visitation if there is no maintenance.
Wonderful, ma'am.
In my case, I know no radical steps can be taken overnight. Our judiciary is already clogged with a lot of things, but some kind of an attention of the legislation and the judiciary to this exceedingly crucial issue of a child custody, child visitation has to be given, because ultimately it is as crucial as any other issues that come up before the court, because you're talking about a tender child's mind and what aftermath it will have in case is not given the proper guidance. Today, it is not a fight of a right of a father. It is a fight of a right of a child to be with both the parents and absorb and learn and enrich with all that is available between both the parents that he or she has. And I think that is where all the systems should come in place to help the child to flower into a better thing. And I think we owe it to the child who's caught in these custody battles.
Wonderful, ma'am. As we come to the end of the 266th session, may I request Kivija Rao sir to offer the concluding remarks.
I thank everybody who's here on the platform. Anil Malhotra ji, I've lost. I mean, my words are over. For gratitude, Mrunalini ma'am, thank you for being here. And most of us, I mean, I come from an industry where 60% face this problem, and I've seen it firsthand. So I know what you are discussing. Having said that, as Shyam sir said, why should there not be a legislation? If the legislators don't legislate, let the courts do it. What will happen? The legislature may come down on the courts. At least then they will be awakening. Sometimes offense is the best form of defense. So why not do it in courts? Why not let the courts do it? Let us see who will take a stand against it. But if you don't try, you're not going to go anywhere. We can have as many discussions as we want. But like Anil Malhotra said, told that gentleman, file a habeas corpus. Now the man has to decide whether he wants to take it there on that side or no. So ultimately, unless you try, you're not going to get results. I know it is like breaking your head against the wall in trial courts, because I appear in trial courts as party in person. I know what it is. But sometimes the judges do listen to you. But just because it doesn't happen most of the time, it doesn't mean it will not happen. If it happens, it's a miracle. If it doesn't happen, you're facing it any other way. But you need to try, and unless we try, we're not going to succeed. Because understand one thing, our judiciary works in a very different manner. And your trial court judges do not come from, I would not say better surroundings, but socially not better surroundings, because they have that mindset that woman, man, this is what their job is, this is what it is. So we need to break those boundaries. And the only way you can break those boundaries is if you can put forth an idea. You have to put forth the idea to the court. The court may accept it, the court may reject it, but unless you try it, you're going to be where you are. If you have tried and failed, failure is the stepping stone to success at some point of time. And if you're going to wait for legislation, let me tell you, it is not going to happen very easily because the legislatures are more bothered about how to line their pockets. And I'm saying this with the fact that I might have to face contempt. There are so many things that the legislature needs to do, but tell me, what does the legislator do? They don't do anything. Once in 5 years they come, we give our votes blindly to them, and after that it's forgotten. So don't wait. It is like waiting for somebody else to do your work, and he's not going to do it. There is no incentive for the legislature to do anything on this aspect. And as Anil Malhotra sir said, Mrunalini ma'am said, yes, let the courts do it. What will happen if the courts do? The legislature will come down heavily on them. Then the courts will say, you didn't do it, so we were forced to do it. And as Vishaka guidelines is the best example. As ma'am said, I come from a field in the aviation, sexual harassment at workplace is a common denominator. And if not for Vishaka guidelines today, you would not have your internal committees with an NGO as a head. These things came in later because the courts legislated or the courts laid down the guidelines. They were foresighted judges. And let me tell you, I've interacted with AP Shah across the bench and the bar. And I can tell you, he's a thorough gentleman. He will let a litigant speak out his mind, and then he will tell you why it is not acceptable. And if his report is lying somewhere, so you imagine then what a common man can do. So the common man is left with nothing but to fight and fight and fight strategically, as Anil Malhotra sir said. I mean, Anil Malhotra sir is an encyclopedia on this. I've heard him n number of, that's what I said. I don't have no more words to express my gratitude to him. Because I've heard him that many times on this forum. And I have to thank Shyam sir, because you understand that you have a webinar that has gone on for 2.5 hours. And not one participant has been cut short when they were speaking. This is one of the best platforms. And let me tell you, I am addicted to this platform. Because I've learned a lot on this platform. Because wise people like Anil Malhotra sir, Mrunalini ma'am, they all come here, they give, because they have experience. They have done, they have tried to beat the system. They must have had success in some, they must have failures in some, but the failures must have taught them where they went wrong so they could achieve success the next stepping stone. So my sincere advice is, let us not wait for legislation. We have to fight our own battles. Nobody will fight your battles for you. So please take advantage of what has been spoken today on the platform. Thanks to Shyam sir. And let's go home enlightened or with a little bit of a vision of how to go ahead. That's all I can say. Thank you very much. And thank you for letting me speak, Shyam sir.
Sir, in token of your appreciation, I will request you as an aviation expert, please recommend Branson or Malya to give me an aeroplane.
Sir, both Branson, maybe we could put in a word, but Malya sir is going to be difficult. He's been dishoused himself.
I only want to fly up to Kerala.
Sir, you get a plane, but
you want me to arrange for an aircraft to take you from Delhi to Kerala? I can do that, sir. That's not a problem. Chartered aircraft.
I was talking about a chartered flight from Chandigarh, direct to Trivandrum or Kochi.
No, we can make arrangements. That's not a problem, sir. That's absolutely not a problem.
So, sir, when we come to the end of the 266th session, who should I thank? Starting from Justice Mustaq sir for introducing Anil Malhotra sir into this platform, number one, and Mrunalini ma'am, you're part and parcel of this entire platform, in the sense like it has been a wonderful experience that a Saturday evening, I never thought that could be well spent like this. None of us did. It's really wonderful, and I'm sure that those thought patterns that has been ignited in the minds of the persons, all of us, could carry it further. And for that matter, this is Ramesh, sir. Thank you very much. And to all those persons who have been present today in this platform, it has been an enlightening, enlivening, and wonderful evening. Thanks to you, Anil Malhotra sir and Mrunalini ma'am, and the Chief Justice who adorned the first half an hour. Wonderful, sir. Thank you.